Hey, folks.
Hey, everybody.
Hey, Greg Siskind here, Robby Rubin, and welcome to our live stream for January 21st. Robby and I we're just talking about that it's kind of a slowish news week, and we'll have very little to talk about other than maybe reviewing some things that are not breaking news, and then of course. Elisa Taub, our law partner, is like she's Walter Cronkite, and she always is if there's anything that comes out, she immediately posted in our internal Teams channel at our law firm on there, and I just saw that she posted something 2 minutes ago that seems fairly serious. Well, it is very serious. I mean, Robby had some choice words about what is wrong with these people right before the call. So we're going to talk about this memo, and I'm going to share my screen because I haven't read this thing yet. I've just seen a description, and we're going to look at it in real time and see what we can make of it. So hang on a second. I have to do the share screen, which is, where is this? Okay. This is a memo from a whistleblower or an email from a whistleblower who I guess was somebody internal at DHS. And they made public an ICE memo that basically instructs officers to break into that they can break into homes without warrants, which is a major story. And it will be I imagine that this is going to be something that a lot of people are going to talk about because it basically says that the administration is about to. This would explain a lot of what's happening with ICE breaking into people's homes. And people saying, "Where's your warrant?" And they're still breaking into the homes even without the warrant. So what this Whistleblower Aid is a legal defense organization. There's a couple of them out there, but they represent government whistleblowers that are using various whistleblower laws to get information out and also to have protection from their identity being exposed. But anyway, they claim to represent 2 U.S. government officials that are blowing the whistle on a policy directive. The directive authorizes ICE agents to enter homes and residences without consent in order to conduct arrests and removals without a warrant issued by a federal judge. We have seen, yeah. So Robby, go ahead, Robby.
Yeah, I'm reading this at the same time as you are, but it looks like the gist of this is that when an immigration judge orders somebody removed, they will assign ICE has a form called the Form I-205 that allows ERO officers and ICE agents to effect the removal, but only in public places. It does not authorize that. It is not considered a warrant at all. It is just an authorization to make to make an interdiction in public for somebody that has a removal order, and that the immigration judge ordered, and signed this Form I-205, which is an ICE, some ICE form.
And Robby, you know a lot about that because you were a clerk in an immigration court.
I was, yes, for 2 years in Miami and a year in Memphis. But the truth is that my exposure to these cases usually ended at the order of removal or grant of relief, which happened too infrequently, unfortunately. But so I wasn't privy to this stage of the proceedings. But yeah. What I'm seeing here, though, from what this whistleblower document is saying, is that what the agency has done is essentially authorized ICE agents to use this Form I-205 as a search warrant, which it is not.
Well, let's go through it a little bit. So basically what's happening here is that the actual memo itself, I'm not sure if let's see if it's actually attached to it or not. but it's this looks like it's sort of a memo that is describing something that they have, and it's 24 pages, so it's fairly extensive. We're not going to go through all of it, but we'll go through at least the summarization. So it's basically saying that because the whistleblowers it's really important, especially here where there's probably a limited number of people who had access to this memo. That they are trying to give information out without being really careful to not to identify anything that would potentially jeopardize the anonymity of the people that are trying to get whistleblower protection. So they say basically there's a memo that's dated May 12th.
Yeah, if you scroll down to page 17.
Yeah,
it has the actual leaked memo on. Yeah, there you go.
There we go. All right. So this is something obviously that no one has. When utilizing Form I-205. So Robby, that's exactly right. Is what you were just talking about. So this is basically it's saying that the warrant of removal Form I-205, they are now saying that itself is supersedes, I guess, the Fourth Amendment requirements to actually have a search warrant to enter somebody's home on there, and you're succinctly saying that is not what an administrative warrant. And remember, immigration judges are administrative law judges. They are not federal judges. They don't have the same abilities as far as being able to, the signing off on warrants for the more extensive warrants that are involving these kinds of constitutional protections that a federal district court judge would have available.
I mean, if you look at the beginning, the first sentence of the second paragraph is striking. Although the U.S. Department of Homeland Security has not historically relied on administrative warrants alone to arrest aliens subject to final orders of removal in their place of residence, the DHS Office of General Counsel has recently determined that the U.S. Constitution, INA, and immigration regulations do not prohibit relying on administrative warrants for this purpose. So with basically just this stroke of a pen, they said, yeah, it's okay, we can forget about the Fourth.
Yeah. Constitution is no longer is just overkill. Okay, so this is the good news about this is now that this is public, and it's no longer anecdotal. What's been happening. This is, I presume, we're going to see a case probably filed. I would imagine that's going to be filed in the next 24 to 48 hours. To enjoin this memo on here. It's crazy that they, equally apply. Standard exceptions to the Fourth Amendment equally apply in the context. Oh, who signed this thing?
Todd Lyons.
The director signed it, but where do they? Do they have any lawyers that look like they, it's usually, when you expect this to come from general counsel?
It says that general counsel it was part of making the determination that Form I-205 trumps the Fourth Amendment, but it doesn't look like we get the end of the.
All right.
So
this is really serious. I imagine this is going to be front page news tomorrow around the country if this, on here, but or maybe not. This was dated January 7th, but I haven't seen any reporting of this yet in the news until tonight. And I think maybe this is the first time they're releasing this document for public consumption. They might have been representing, as part of the litigation to protect the whistleblowers. They might have not published this yet. But anyway, that's that's this news. And I'll take that out and we'll get back to discussing others. So stay tuned for more information on this, because this is actually a fairly common tactic. This is not just sort of every once in a while ICE is breaking into homes. It seems like this is happening, especially in Minneapolis, where it's been reported over and over again, that people are being followed into their homes by ICE. And my guess is that they also are treating them like if somebody is being chased down and they go inside their home, they're sort of like treating it like sort of hot pursuit of a criminal. But that's not, these are civil violations that we're talking about. So they still have to have they still have to abide by the Fourth Amendment for that. So anyway, that's crazy. Yeah. Okay. Let's move on to other topics. So, Robby, you're the topic steerer. What's first on the agenda?
Well, I thought that, I know we talked about some of these things last week, but I figured just because last week was just such a huge there was a lot to talk about last week, and I'm not sure that we have 100% overlap in our listeners. So I figured I would just do a quick recap of two of the bigger things that happened last week. The first one, and we discussed both of these last week on the live stream, but and I think we've learned some more information, especially about the immigration visa processing pause. So the administration announced the pause of issuance of immigrant visas for nationals of 75 countries. And so at first it came out, we didn't know, is it going to affect NIVs? Is it going to affect IVs? Is it just consular processing? Is it USCIS benefits too? So turns out it is just not just as in it's not a big deal, but it is a pause on the issuance of immigrant visas to nationals from the listed 75 countries. And I think a lot of, not all the 39 countries that were previously banned and also subject to the USCIS benefits pause are listed in that, are part of that 75 country immigrant visa issuance pause as well. So that, is just another blow from the administration to slow down or basically just freeze all immigrant visa issuance. We call it immigrant visa issuance because you can technically still go to process your immigrant visa. You can still file, if you're national of one of these countries, you can still file a DS-260. And you can even, according to the memo, as we first read it, you can even go and do attend your interview, schedule an interview, attend your interview, and it'll go through processing, but no visa will be issued until the pause is lifted.
Robby, aside from this is coming from the State Department and it's a visa ban. Do we know if there's any kind of proclamation or they're citing, what laws they're citing for this?
Was it 212? Was it?
Yeah, they might be citing that, but usually there would be an actual proclamation or an executive order.
Let's see. I can pull it up.
I don't think that's come out yet. And that's important because that also outlines, for example, national interest exceptions and other kinds of things.
Right.
We had
there's no guidance yet, I don't believe, for applying for these exemptions.
Yeah, so that's important as far as the that.
But presumably it'll be the same.
Something's happened to your sound. Want to try to repeat that?
I was just saying that presumably it'll be the same. The NI, the national interest exemptions would presumably be the same as we've seen in the past. Pretty basically extremely limited, and or for the World Cup. But I guess they wouldn't really apply for an immigrant visa, of course. But
we're going to talk about the World Cup in a little bit because there actually was some news on that this week too regarding visas. But we don't have an executive order or anything yet showing the I think what
all we have so far is
they're not claiming it's a ban. I guess it's just a pause to sort of retool their their screening efforts or something like that. They're trying. I don't think they're. I mean, they're trying to squirm out of trying to say it's a ban on there, but we don't have anything other than this State Department announcement. The State Department announcement doesn't actually have a national interest exception part of that announcement, as far as when we were looking at this one as the news broke last week, and I don't think we've seen anything further on that since. And it's pretty sweeping. I mean, I had a celebrity client of the firm who has who's a U.S. citizen and has been, is in the middle of processing to get a parent to the U.S. And the parent's a successful professional in one of the countries that's on the list, and it's like there's no exceptions for anybody yet in here. It's pretty much it's across the board, and it's there's not anything now. Whether they will informally deal with certain situations that are brought to their attention, maybe, but they certainly haven't provided any information on how that's going to go. So what I will tell people is that some of you may know that we have a lawsuit we've been working on the other ban, the 39 country ban, which that one covers all on the entry side of things. It covers both all non-immigrant and immigrant visas. It's also barring I should say it's barring entries for the 39 countries on non-immigrant or immigrant status. It's barring the consulates from issuing visas to anybody that's covered. And there's a separate memo from USCIS that's pausing any kind of benefits, anything ranging from a change of status application for a non-immigrant, changing categories, green card applications, all the way up to citizenship applications. And all of that is halted as well for the 39 countries. We are gearing up to litigate the 75 country ban. Right now, it's just dealing with the State Department because that's all that's actually been announced. So we don't actually have we don't have a memo yet from the USCIS regarding pausing benefits or anything like that. If that happens, of course, we will look at litigating on that issue. But the reason why we think policies like this are illegal, other than we think they're bad policy and we think they're mean-spirited, but they're also illegal because INA, that's the Immigration and Nationality Act, Section 212F, gives the president the ability to bar the entry of individuals or groups of individuals that the president determines to be their entry to the U.S. would be contrary to the interests of the U.S. And that's a very narrow and specific power that the president gets. Now, historically, it goes back to the 1952 Act during the Truman administration. What was going on in 1952 that caused them to add that? We were in the middle of the Red Scare and the anti-communist movement, and there was a concern that we needed to have a provision like that so the president could keep out suspected communists for coming into the U.S. There's a broader history as well of that having to do with this was that 1952 is also the beginning of the refugee program for the United States. There were there were a lot of concerns about Holocaust survivors that were in displaced persons camps, and some of them had backgrounds that were fairly left wing. And this was all going to be an effort to try and thwart the entry of some of those folks. Not to mention the fact that there was a whole program for to encourage ethnic Germans that were living in East Bloc countries that were seen as being very anti-communist and were being targeted for persecution by the new communist governments in Eastern Europe on there. So it was kind of a little ironic that we were letting Nazis into the country, but the actual Holocaust victims were being kept out partially with 212F. But fast forward 70 years, plus years, the administration is using that pretty much for barring just about anybody that they want. So What it doesn't do is it doesn't allow the president to bar the issuance of visas, and it doesn't allow the president to to stop issuing benefits in the United States using that section of the Immigration Act. And there have been a number of lawsuits since the first Trump administration on the very issue, some of which we were involved with as plaintiffs counsel with our impact litigation team. And there's 4 law firms that we work on those cases together. And we successfully sued to force the State Department to issue visas. Mostly the big cases that we had, but we had they weren't the only ones, but we did 6 cases specifically for K1s that were not able to come into the U.S. due to travel bans imposed in the wake of the pandemic on there. And judges, the judge, we prevailed at every one of those cases. One of which had 900 couples. That's still the biggest case we've ever worked on as far as number of plaintiffs. So we know the issue really well, and we're going to be litigating on that again. And if a USCIS adds if they decide to get in on the action and try and do a benefits pause for immigrant visas for the 75 countries, that also would be a problem. So I'm just going to I'll pop onto the screen. This is the web page. If you go to Impact Litigation, IMMPACT litigation.com, you'll see the onboarding page for the 75 country ban. And then you'll see there's an FAQ, an engagement letter, and you can see how to join the case if you want on here. So we'll keep you guys up to date as far as this case goes. But I did want to let people know that it is going to be happening. I don't know which court yet. I don't know, and I'm not going to broadcast to the Department of Justice what our specific strategy is. But you can read our past cases suing the State Department over trying to extend a travel ban to visa issuances, and you'll have a pretty good idea of the likely arguments that are going to be coming. So, Robby, anything else we want to talk about with respect to this policy?
No, I mean, I think I think that really covers it for the most part. If you're a national of one of those countries, and we got a question that we can answer too, but if you're a national of one of the 75 countries but not a national from one of the 39 countries, then you are still eligible to process or to file for an immigrant visa, via adjustment of status if you're in the United States.
Yeah.
So it's not
so far. There's nothing that's happening domestically
on those 75, correct?
Right, on the 75.
Unless you're on both lists. If you're on both lists, then you can't do anything at all. Well, right. I guess if you're on both, if you're on both lists, you definitely you can't do anything.
Yeah. So anyway, that's what's happening.
So Orlando asked a question. He said, "Does the 75 country immigrant visa pause affect AOS or NATs in the U.S.? Thank you." So the answer, we basically just, the answer to that question is no. The 75 country ban does not. No.
39 country ban does. The 75 country ban does not.
In a lot of, but a lot of the countries that are in this, just say, if you're in both, then yes, of course, it still applies. So yes, the 75 country ban itself does not have any impact on AOS or NATs. No.
Yeah. Okay. So Robby, that was the 75 country ban. What else you got on your list for us to talk about tonight? I know there's some court cases.
We got some court cases. There's obviously been the one other thing to recap in terms of kind of just department policy. On the flip side of all of this bad news is that we talked about this a little bit last week. We got some good news for religious workers, which has already, like in my practice, has been like, a very, very big, sigh of relief for a lot of my clients. That is essentially just going to allow for the continuity of religious workers within the United States. What the regulation will, is purporting to do is, instead of, at the end of your 5 years, you have to go back for a full year to stay out of the country, which, is something that a lot of religious workers are butting up against, this 5-year maximum period that they're allowed to be here, because their religious work green card category is so backlogged. So before this new interim final rule, you'd have to leave for a full year and then come back on a new R1, which is obviously for, like, religious congregations and organizations to have their spiritual and religious leaders gone for an entire year is very difficult. So this new regulation would say that you have to leave after the 5 years are up, but you can go out for one day, and you just have to get a new visa and you can come back in. And, so that gives you, in theory, you could, I guess there's no maximum, you could just keep on, you could keep on every 5 years having to go out of the country and coming back on a new visa. But in theory, I would imagine most of these people would probably have pending, pending or approved I-360s in the meantime. So it allows communities to retain their religious workers, past the 5 years that they were originally allowed, and let them remain in the United States until they're eligible to file for their green card, which is very, very welcome news.
But if you're on the 39 country list,
right,
you have a problem, because if you leave the country,
you can't come back.
You're not coming back in on there. So it's great news for everybody, but that group for now, unless they can somehow. That would be, I'm imagine when that will be an interesting area for litivation.
Yeah. And there's some questions, like, I've had some discussions and reading some questions my colleagues have having on listservs. It's unclear, like, they're going to have to figure out how it works, because, let's say, how do they determine which, if you've been here for 4.5 years and you leave, and, then you get a new visa and it's unclear, like, which departure will trigger, the new 5-year clock. But there'll be some out, but I've already seen some of the comments that people have made to the,
and this happened because of litigation.
We think, yes.
Well, no, I mean, I know what DHS told the judge in the New Jersey case, which was that they agreed to voluntarily dismiss the case, the plaintiffs, in that one, based on representation that was made to the judge that they were going to issue a regulation that largely solved the problem on there. So if they were planning on doing that on their own, that's one thing, but that's how they got out of this lawsuit.
Right. So, that's the Catholic Diocese lawsuit.
Yeah, the New Jersey case. Okay, so that wasn't technically one of our litigation questions, but that was the one good piece of news. We talked about that a little bit last week, but I wanted you to talk about it, Robby, because you work on a lot of those cases, and I'm sure that for a lot of people, I just had the day that case came out, I had somebody that was inquiring with about trying to figure out if a clergyman could do a national interest waiver.
Yeah.
On there, and people are coming up with all kinds of strategies to try and work their way around this particular problem. So this is going to make things easier. It's not going to get them green cards faster,
correct,
but it will allow them. In some respects, it's very similar to the H-1B extension rules, which, if you're Indian, you don't think then it's not so peachy. As far as that goes, where it's thank you for letting me extend my H-1B beyond 6 years, and that's all well and good, but I'd like to get a green card sometime before my 100th birthday on there. And we're not at that stage yet with the religious workers, but this is these waits that they're on, the line that they're on is pretty long as well, and it's getting longer. So we will see how that
the truth is it might get even longer now. I mean, they're because in the past, I could imagine people not even really bothering maybe to file an I-360 for an EB4 because there was no pathway to make it work.
Yeah.
So, I mean, it might not be a significant amount but could see an uptick.
Yeah. So we had a case in many, so we haven't talked about it yet, but it's something that obviously people are talking about all over the country, and that's what's going on in Minnesota. And there was legal news there this week with respect to a case, but there's sort of this general issue that, and I guess this whistleblower thing that we were just talking about is related to, it covers that subject as well. But there have been, if you're on social media, it's hard to avoid lots of videos and stories being posted about U.S. citizens that are being basically roughed up by ICE. And there was a story that kind of struck me. Maybe it was I think it was yesterday or the day before. I think it was yesterday. With there was a news conference by it looked like 7 or 8 local police chiefs for the towns in the metro area for Minneapolis, St. Paul, and what triggered that news conference was apparently an off-duty policewoman was roughed up by ICE, who where they were demanding her, she wasn't in uniform or anything like that, and demanding that she prove that she was a U.S. citizen. She apparently decided this is a good time to take out my camera and start filming what's happening, and the police chief that was describing this of the officer that he is that's under his command described it was that they grabbed her phone, they threw it, or they hit her arm or whatever, and apparently she got she was treated pretty rough. But I mean, and then what they said was this was not just one police officer that's had that happen, but apparently a number of officers that are off duty have had that happen to them, all of whom were people of color, and it's and we've seen the videos as well where we see ICE officers basically ask people, it's like, well, why are you stopping me? I'm a U.S. citizen. Well, you have an accent, so that puts you under suspicion. I want you to prove that you're a U.S. citizen. So somehow having a foreign accent is an immediate indicator that somebody's not a U.S. citizen, even though we have, I don't know, at least 14 million naturalized citizens in the U.S. I don't know what the number is, but it's a very large number of U.S. citizens who were born in other countries, and they have all the same constitutional rights as anybody else. So using an accent itself as an indicator of somebody's immigration status. And plus, aside from that, you have probably a even higher number of people that are permanent residents of the U.S. That are also have all the same rights. So that was happening. We were having a discussion today, Robby, at our attorney lunch about, obviously there's big constitutional questions about what that's right or not, but a practical piece of advice that we could offer clients was, it's not the carrying your passport around. That makes a lot of people nervous. A lot of people keep their passports in safes and things like that. And it's not the kind of document that you usually would just carry to the grocery store. But there is a document that you can have that does largely the same thing. And it's a U.S. passport card, which a lot of people don't even know that there is such a thing as a passport card. But basically what it is it's essentially looks like a driver's license. It's a photo ID. You can apply for a passport card at the same time you apply for your passport. You can file for it independently. And it is a proof of citizenship that you can stick in your wallet. It doesn't substitute perfectly for the passport book, which you would need if you're traveling into the country by air or ship, for example. But it does work at land ports if you're crossing into Mexico or Canada, or coming back into the U.S. from those locations. You can enter on your with a passport card. And it is something that I have a passport card. I have to confess I haven't really I don't carry it on me, and didn't think I ever would need to. But I can tell you, sort of after what's happening in Minnesota, I'm going to stick that in my wallet as a document that I regularly have on me. But that is something that people might want to think about to to get that. Somebody had asked the question, do you have to send the passport to them to get a passport card? I don't. It's not. No, I don't think. I don't. No, I don't believe you have to do that. You have to send proof of citizenship in order to get the passport card, which would be the same way you would apply for a passport book. You would either, have you'd send a copy of your birth certificate, or you would have a copy of your naturalization certificate or such. But Robbie, I don't know that I don't think you send them the passport book. I think that would be the case if you were applying for a new, a replacement passport, and don't send the original naturalization document either. But you on there. So, and by the way, I'm not claiming I'm an expert on filing for passport cards. On there, it's not the kind of thing you need a lawyer for. Most people would do this themselves. But it is handled by the State Department the same way passport applications are. Passport books, you do have to send in an expired passport in order to, or an expiring passport in order to get a new passport book. I think unless it's lost, in which case you wouldn't be sending in the old book because it's not in your possession. But that's one thing that people can look at doing as at least as something to have easy proof of them, of their status. So you were going to say something?
Yeah, I mean, it looks like I mean, I'm just on the State Department's website. Birth certificate.
You want to share what that's on it's at travel.state.gov?
Yeah, I'll send it to you.
Send me the link in Teams and I'll go put it up on the U.S. citizen travelers. What do we want? Passport applications. So put the link in Teams and then I'll go and I'll do it.
I just said it.
Okay. All right. So I'm going to put this on the screen so people can see what we're talking about. Where is this? Apply for your pass. Okay. Just a second. Here we go. All right. Robbie, this is the page? Yeah. All right. So what we're talking about, this is the document on the right is the U.S. passport card. And like I said, it's the size of a credit card. It's cheap, $30 compared to $130 for a passport. And again, as we mentioned, it can be used across land borders. But it is proof of citizenship that you can have, and you can apply for it at travel.state.gov. Steps to apply for a card. So applying for the first time, you should still be saying it on here. Yeah. What do you fill out the form, print it, give evidence of U.S. citizenship. So your evidence must be of citizen must have the original official stamp, and you must provide one of the following documents. So usually, Robbie, I think that's still, well, I don't know if you send it in, or it's at the state when you go to the post office to apply, and that's how a lot of people do it. I don't know if they just look at it there and give you the document back. But anyway, this is where you would find the information on filing for that. So we were just mentioning that as sort of in passing in our conversation today, that it's something that we could tell clients that they could do, and it might be something that's useful for people that are watching this to get that.
Yeah,
It's a relatively inexpensive investment for the document, and it might be something that helps people sleep a little better at night.
we had a question about if they send in like the naturalization. So yeah, so it lists a bunch of different ways that you can do it. It lists so if you have a birth certificate, and if you're born in the U.S., you can send your birth certificate, or you can send in a U.S. passport or a certificate of naturalization or citizenship.
Yeah. All right. So also in Minnesota this week, there was a really important case that was heard by a district court judge. And before we were doing this, it was Robbie and I were playing with the software product that I'm involved with as a co-founder of a company called Visa. And I asked I couldn't remember the name of the case on there, so I used the tool, and I thought I would do a screen share and kind of show you what we were looking at before when we asked it, just because I think it's cool that these kinds of tools that are now available to immigration lawyers. So, Robbie, I'm going to share my screen for a second, and we can talk a little bit about this case. So, I had I'll just show you on here. So, I initially asked this question. This is a legal research product that is for immigration lawyers. That like I said, I'm a co-founder of this company, and I had asked this question: what was the Minnesota District Court? I didn't even finish type in this thing correctly. I should have typed in the word case that dealt with the ICE tactics involving protesters. It's all I had. I said it was recent, and I gave a little bit of description of what the case was about. And then we have what's the world's largest immigration law library is actually powering the product on here. And we have every day, usually 40 or 50 documents that are added in. You can just see these are all things that were added today. And it's usually whatever cases were there, any documents that came from the government. And then going back into the chat, let me try this again, paste that in. And it will produce a really in-depth legal memo on whatever topic. So this was a case that was from a couple of days ago. Well, the Tincher case was actually from late December, but there's another case that that came out a couple of days ago that's also comes up in this memo, because I was not particularly precise as far as what I was looking for. But you'll see this document that's here, and it has the case citations here. If you have that case was cited in another case that just came out a couple of days ago. This was the one that made the news this week, Robbie, that I believe this is the case about tactics that ICE officers can use against protesters. But anyway, it's kind of cool that this is that it's available, and it also kind of goes in for the legal nerds out there. But goes into the what the claims were about, and then talks about its connection to other cases that are being heard in other cities. And the case itself, the complaint itself, talked about specific incidents that had happened in the Minneapolis area. Anyway, that's how the subject came up, because I couldn't remember specifically which case we were talking about. In this case, it was the Minnesota versus Nome case, but it also was referring to this other case, and all of this is available. And then it also highlights for lawyers the section of the document that the AI was pulling from. So some pretty cool tools that lawyers have now that they can much more quickly get to answers in cases. But Robbie, this was a big defeat for the government. And I haven't really sort of seen how it's going to play out yet. But basically, what the judge said was that peaceful protesters, you can't respond with with violent tactics, and so the pepper spraying and these pulling phones out of people's hands and things like that, all
Yeah.
that all that's illegal.
Well, yeah, it's nice. It's nice that we have a judicial order saying that, but if they're allowed to break into your house,
Well, but the thing about it is, if you have an order like this now,
right?
Everybody's filming everything, so there's now some pretty the ICE officers should assume that these things that they're doing are being filmed, and now that there's a court order saying you can't do that, courts have a lot of power. They can send the marshals out to basically arrest an ICE officer for violating a court order on there. The administration can't protect individual officers from something like that if they're outright violating a court order. They can try and fight the court order, and I'm sure they'll try and appeal it, to the Court of Appeals and maybe the Supreme Court. But an order is an order. I mean, they've had to turn planes around and bring people back from CCOT and all kinds of things like that. So the administration so far seems like they complain a lot about judges, but they're not willing to cross the line on that, because when that happens, there's actually a lot of consequences that would happen. So any lawyers, for example, for the Department of Justice, that advise DHS that they can ignore a court order, for example, they can be disbarred for giving advice like that, to ignore a court order. That would be something that would probably be a violation of about 18 different ethics rules, and a judge would probably do that. And in fact, judges have more recently, I think in the case to yesterday of the woman who was the U.S. attorney that were claiming to be the U.S. attorney, Halligan, in Virginia, in the James Comey and Tish James cases, that was illegally appointed to the U.S. attorney. The judge said, you can't call yourself the U.S. attorney. And she's been apparently continuing to call herself the U.S. attorney. And he was threatening to turn her over to state bar regulators for disciplinary action if she ignores him any further. And apparently she stopped on that. But that seems to get their attention. But anyway, that being said, that's with the if we see outright violations that are filmed, my guess is they'll go back to this judge and claim that they're violating the temporary restraining order, and then you could see various sanctions come from that. So we will see on that. But I know the lawyers for the agency are probably being super careful because they have careers that are potentially ruined, for the if they follow along doing things that are unethical or violating court orders. So we'll see on that. I don't know if there's if you have any further thoughts on that, but there was a case that was similar to this in Illinois after the Chicago stuff started. This one looks a bit stronger, and obviously the Minnesota situation has gone a lot further than what was done in Chicago. But we will see how this plays out. All right, Robbie, what do we got next?
We got. Did you want to talk at all? Another thing that we talked about at our attorney lunch today was a lot of the rejection notices that we've been getting for forms that are completely and totally properly filed with the correct.
The title for this story is like, be nice to right. Don't immediately accuse your immigration lawyer of being incompetent when stupid things happen in your case. This is not a new thing, but there's always sort of been this thing where, like, a document that you submitted will get lost, or this sort of like used to be like, a check. You'd send a check with the case, and then you would get a rejection saying you didn't include payment with the case, and you included payment because you had a copy of the check and the on there, and that's why we staple checks now to applications because too many.
Well, we don't do checks anymore, but yes.
Right, but you get the point is the same on there, which is that we these dumb things happen at the in the mailroom and other aspects of things that we do, and we've just noticed a lot more problems in the mailroom that are happening now that are creating all kinds of issues. So, Robby, there were some examples that were talked about at the lunch today that we're hearing from other law firms, and it's a just keep that in mind that your lawyer, if your lawyer says that it shows you that you got a rejection of an application because something wasn't sent, don't immediately jump to the conclusion that your lawyer doesn't know what they're doing. More often than that, I would say probably 90% of the time, something got screwed up on the USCIS side and not your lawyer's side on there. We do actually now, for that reason also, we are filing as many cases as we can electronically instead of using paper just because of so many problems with the mailroom. But there are some things you can't file electronically. There's still a number of applications where you don't have a choice. You have to file by paper. So, but for lawyers out there that are listening, particularly the newer lawyers that are out there who I think haven't been jaded enough through experience of these kinds of things happening, you should assume that you're going to have problems if you're filing by paper, at least some of the time. And there are things you can do to kind of like maybe minimize. So some of the techniques that we've had over the years, like in the petitions themselves, like highlighter pens we'll put on envelopes, it's like underlining, do not open email, or like things like that on there when we, for things that we know go wrong once it gets there. The mailrooms, by the way, are run by outside contractors. But it is so sometimes the quality of the contractors can have a big impact on what's happening in the applications.
One thing we've been doing recently for cases with multiple applications, because we were I think there was a lot of issues at first with the G1450, which is the form that we use now for the filing fees.
That was a chaos for the first couple of weeks after that.
Yeah. And it's gotten better, but we were noticing that we were getting rejections for cases that had, multiple, if there was a I-129 extension and an I-539, or if it was adjustment of status with a 131 and a 765, they would kind of like only see the first G1450, and see that, it only has the $1,440 for the adjustment of status. It doesn't have the filing fees for the 765 or the 131, and then they would just reject it. So what we do now is on applications that have multiple different filing fees, we'll put on the very top page will be in big, bold letters. Attention USCIS, this application, and all bold underlined, this application has multiple G1450 fees for multiple applications. Please make sure to see each one. So I think that's helped. I mean, I don't know if that's helped or if they're starting to figure it out a little bit. But that's just one of the tricks we've had some success with. But yeah, it's frustrating. And, we end up sometimes with clients that they get an improper rejection, and now all of a sudden, they're out of status because they were banking on it, their, extension being receipted before their status expired. And they get a rejection too. We had John, a partner at the firm, mentioned today that she had a case that was receipted. She got a receipt notice for it, I think she said this summer. And about like 5 months later, in December of this month, she got a rejection notice. So I had never heard of that happening before. And so that's extremely confusing. I don't really get how that is possible. But just kind of shows you the extent of the chaos that can be going on in these
I mean,
mail.
one thing that clients can do with to help their law firms out, though, is don't wait till the last minute to get your law firms the documents that they and the information that they need from you. Um, the faster you turn around what's requested, and the earlier that the law firm can file. Now, don't just don't expect them to take an unreasonable. I mean, to work the case faster than they normally would. But the earlier you get documents to them and the earlier that the law firm can file, if there is a problem that happens in the mailroom or somehow with USCIS, there may be more time to be able to fix the problem before there are all kinds of serious consequences because the I-94 expired or whatever has already happened. So the faster you are as a client in getting information to your firm, to the firm that's doing your work, the better served you're going to be. So,
and not just and it's obviously at our firm we have reminders for all the attorneys. So like I have for all my cases when I have an extension that's due in June, if once the 6 month part, I actually set mine out to 7 months. So that way, because the earlier you can get these extensions filed, the more cushion you have. But sometimes things slip through the cracks, so it's good as a client to advocate for yourself. You should also be aware of when your status expires, and you should feel free to reach out to your lawyer if you feel like your extension's coming up and you're getting nervous, and that sometimes there's nothing wrong with advocating for yourself.
Yeah, and that's sort of like another thing that it's like you'll talk to 10 immigration lawyers, you'll get 10 different views on it, but some immigration lawyers are like really unhappy with generative AI right now, and the fact that so many of their clients are using it to learn more about the process on there, and some of them like me, I like clients to the more educated they are about the process, the more likely they are going to follow your counsel and be aware of things where they're not going to do things that are going to get themselves into trouble as much because they're very educated about the process and what's going on there. But there are with that being said, I was at a conference this past, actually earlier this week with law firms. They weren't immigration lawyers, but they were in other spaces. And one lawyer told me he has a clause in his engagement letter that if you ask him to review something that ChatGPT or another generative AI tool came up with, that he will charge double his hourly rate to do that review for you. And it's like, I think that's a little bit overkill. But I do, there are telltale signs as well when I get an inquiry from a client and they have the words bolded and they have all the other things in there that you just know that this whole query was generated by ChatGPT. But sometimes, actually it's useful because they do a better job, I think, of explaining what they're trying to figure out from, what they need from you. Sometimes that they get a little help from generative AI in drafting their query to you. So I'm an AI optimist, I guess, but I wouldn't be in the AI business if I wasn't. But that is something that we're seeing more. But it's sort of in this light of being as a client. I don't think people should be filing in the Trump administration do-it-yourself jobs for almost anything. But I do think clients can go the do-it-yourself route in educating themselves about the law and about the immigration process to become better clients. And I always reminded Robbie, there was a store in Miami, and I think it was up in the Northeast called Sims that I was growing up. And Sims, they had a slogan, and it was like, I'll never forget it because it was on every one of their commercials. At Sims, an educated consumer is our best customer. That was like their whole slogan for this company forever. It was a clothing store on there, and I don't know how they decided that somebody was an educated clothing shopper. But the idea is the same for immigration clients, is that the more clients are educated about the process, the more likely you're going to be able to collaboratively come up with the best strategy for them, and the more likely it's going to work, because the client, a lot of times the law firm is trying to advise the client to do certain things, or to make sure that they're aware of things that can get them into trouble. And the more savvy the client is about the process and following advice, the better. So I'm good with some of those tools. Anyway, that's how I guess we can end things tonight, because it's the top of the hour. Anything else that we didn't hit?
I'm sure that we could.
We got the highlights.
Yeah. Hopefully,
I will not be here. I said I wasn't going to be here last week because my you guys may have noticed I was in Mexico last week. I had a child that got married over the weekend in Mexico, and I was down there for this destination wedding, and it was a lot of fun. Next week, I am going to the UIA to speak, which is an international bar association that is based out of Paris. That is, I've been invited to speak on AI at a global mobility conference being sponsored by them in Lisbon, Portugal. So I will be there next week, and I was telling Robbie that it is way too late in the evening for me to do this next week. So it will be somebody else. I think Marshall, who's been our host before, will be one of the lawyers on, Marshall Garbus. I'm not sure who the other one will be, but there's usually two. So I won't see you next week, but I'll see you hopefully the week after that. And I just want to thank everybody for you guys. I'm always amazed on how many people tune into this every week. I hope you guys find it helpful. I find it helpful just to get ready for this when we have to kind of go through all the subjects that we think we want to talk about. So as a lawyer, it's useful just the prep for this. But anyway, we will see you the next time. And as I say, hopefully it will be a slow news week. That is my prayer for ending, after each one of these, is that we won't have much new to talk about. Nothing bad happened, but we will see.
That's a good sign-off slogan for you, Greg.
There you go. All right. See everybody next time. Bye-bye.